Well, welcome to this session. It seemed important that at an SLS conference we ought to have a session on the issue of the day, and it was important therefore to put together a panel as quickly as possible which explains why everybody to my right and left is from the Oxford Law Faculty. They are going to talk for 5 minutes max, and we're splitting it in this way. We're going to take the constitutional and general issues first, and there are 5 speakers on that. So the Article 50 question, whether you can have unilateral withdrawal having triggered Article 50, what happens at the end of the process. And then in the second half of the programme, and we'll have open discussion after that, open to the floor. That will take us to 2:30. Then from 2:30 until 3 o'clock, we'll have 6 specialist speakers on particular areas. And I have to say at this point that unfortunately Rebecca Williams has been taken ill and is currently in the John Radcliffe Hospital, but she's making and has made, I believe, a good recovery and hopes to be discharged about now. But it does mean that she and her husband John Armour have had to pull out from the panel, but fortunately Mark Freeland has stepped in and he's going to take some of the constitutional issues, and Luca Enriquez is going to fulfil exactly the role that John Armour did. So thank you very much to those two for stepping in at the last minute. It does mean we've got nobody on criminal implications, criminal law implications, so if there are experts here who know a lot about that, we'll try and get you in from the floor. So I'm going to start now with Nick Barber, who now goes up to the podium. And Nick, as you probably know, with Tom Hickman and Jeff King, has written the blog on Article 50. I believe they've had 200,000 hits on that blog. He is the Associate Professor of Constitutional Law, a Fellow of Trinity College. Over to you, Nick.
Well, good afternoon, everybody. When Andy asked me to speak, he said that I had 5 minutes to speak. And I said, that's fine, I'll talk about this, I'll talk about that. He said, you've got 5 minutes to speak. And I could see this sort of steely glint entering into his eye, which is, I'm sure, the sort of steel that has got him to the presidency of the SLS. So I will certainly be stopping after 5 minutes, and I'm not going to go through the detail of my blog post, because I think many of you will have read it. I woke up on Brexit morning, like many of you, with a sense of stunned surprise. Not quite as big a sense of stunned surprise as Michael Gove and Boris Johnson, who, I don't know, were any of you children of the 70s and early 80s? Do you remember that public information advert about the small boys who were playing in the electrical substation, throwing their frisbee? And, well, Michael Gove and Boris Johnson looked very much like the characters in that public information film who'd just, to their enormous surprise, been hit by 20,000 volts in the back of the trousers. In fact, the only person who looked happy on that morning was Jeremy Corbyn, who looked like he'd won the national lottery even though he hadn't bought a ticket. But the key question then is what's going to happen after Brexit, and I have no idea, which is puts me in a similar position to the government. My contribution has been on the question of who gets to initiate Article 50, and on that I do have a strong view. My argument, along with Tom Hickman and Jeff King, is that Parliament has to trigger Article 50, and the Prime Minister, Theresa May, can't unilaterally trigger Article 50 without statutory support. I wrote the blog along with other people. It's had an enormous readership. I'm not going to go through the arguments in any detail, although I will do if you have any questions you want to ask me about it. I will deal, though, with 4 responses that we've had to the blog, 4 critical responses, and give you my reactions to them. The first is, the judges wouldn't dare. That the judges are cowardly, timorous creatures who faced with the case, will run away. Well, it depends what you think is being asked of them. So some of the discussion in what I believe is called the blogosphere has been suggesting that the judges should review the referendum itself. There was even one article I read somewhere where the author bravely suggested that the referendum decision was in itself irrational and the judges should strike it down very easily. If you think that Jeff, Tom and myself are arguing that judges should review the referendum, then I think you'd be right to say that they should steer well clear of that. We're not making that argument. What we're arguing is that the judges should uphold the position of Parliament in the Constitution. So this isn't a challenge to democracy in our constitutional structure. It's an attempt to vindicate the constitutional structure. And the argument flows from the basic principle of the common law, which says you can't use the prerogative to deprive a statute of its meaning. You see this in the case of proclamations, but you see it even more strongly in the case of Fire Brigades Union, a case decided about 20 years ago, I think. And that was a case in many ways that in some ways is perhaps weaker than the argument that will be run before the court in a few weeks' time, because that was a case in which the statute was unaffected. The power in the statute remained constant after the use of the prerogative. If Theresa May were able to use Article 50 in the way that she proposes, the 1972 Act will be deprived of all meaning. All legal consequence will be extracted from that Act. And the common law says if you want to deprive a statute of meaning, you have to get another statute to empower you to do so. It's a separation of powers argument. The second criticism that's been made of the blog post is that use of the prerogative in this way wouldn't actually repeal the 1972 European Communities Act. It would still be there, bravely marching on like some sort of statutory zombie. It wouldn't have any effect, but it would still be on the statute books. So Article 50 doesn't repeal the 72 Act. I think this argument against our argument is mistaken for three reasons. First, a most
Nick, you've got 30 seconds.
It deprives the statute of meaning. There's also the European Parliament Act as well, which gives people the right to vote in European elections, which would also be affected by Article 50, which is an even clearer be undermined. Other argument against us is that Article 50 can be revoked. No, it can't. There it is. Finally, will this all stop Brexit? I doubt it very much, I'm afraid, ladies and gentlemen. The best we can do as constitutional lawyers is uphold the position of Parliament in the Constitution and require that Parliament has a say before all this happens. Thank you very much. I'm happy to answer any questions later.
Now we're on to Alison Young, who is the Professor of Public Law and a Fellow at Hertford College.
Okay, I'll try and be as brief as I can, as we have 5 minutes. I'm also out on the blogosphere, so apologies for that. I think what I'd like to do is just raise two issues. There's basically two arguments. One, we think legislation's needed. Two, it's okay, we go away, we use the prerogative, it's all fine. And there's a little bit of quibbling about whether the prerogative power means Theresa May only, or whether you might need an order in council. So the difficult position is going to be, if we do need legislation, where does the legal requirement for legislation come from? And I think this is the issue I want you to think about. And if you go away and look at the different arguments, you've got Nick and Jeff and Tom's argument that it comes because somehow the statute and the prerogative are contradicting each other, that if you go away and exercise Article 50, you deprive the legislation of all its body. There's no substance to it, it's not there. So my response to that is, what does the European Communities Act 1972 actually say? And if you go away and look at the section, it is referring to the rights and obligations in EU law from time to time as you find. And as we've gone away and modified different treaties, you'll get things like the EU Amendment Act 2008 that says, oh, and now here are the Lisbon things that come in. So yes, normatively, if we go away and leave the rights aren't there, or maybe they are, we don't know what we're going to get from the withdrawal agreement. But if you're just looking at a very narrow legal textual argument, yes, it looks like a zombie, but in a sense, it's just the new withdrawal agreement rights that come in and it's there. So I have a difficulty in seeing the conflict. I'd love it if it was there, but I'm finding it very hard to actually see it. When I go away and look at the other arguments that are based on things like Thoburn, it's a constitutional statute, the ECA is a constitutional statute, it has to be repealed by express wording. Again, I'm still stuck with the same problem. But is an exercise of Article 50 automatically overturning the ECA 1972? I don't think it is. When I go away and look at arguments from the principle of legality and the whole idea that we have these common law rights, that common law rights can then be removed by legislation, and all these rights that we find in Europe are all going to be removed, I look at it and I think, well, that's all well and good, but the principle of legality is to do with common law rights. So as Mark Elliott has argued, either they are common law rights, in which case they're still there when we leave Europe, or they're European rights, in which case they're not common law rights, so how are we triggering the principle of legality? So I love all these different arguments. I think it's great fun. I'd love normatively for there to have to be democratic debate. I can't possibly argue that that's not a good idea. I'm just finding it very, very difficult to see a very clear legal argument that that would necessarily be the case. I think what we're asking the courts to do is to be quite creative. Am I happy with them being that creative? Yes, normatively. But do I really want the courts to be doing that and to force Parliament to act in a particular way? I'm not necessarily so sure. I think the stronger argument is that there is a good, strong political argument for having proper parliamentary debate. What concerns me about a legal requirement for legislation is you'll have a lovely, let's trigger Article 50 Act, Section 1, Parliament endorses the Prime Minister to trigger Article 50, full stop. I would much sooner have a proper, full legislative debate about the ins and outs of what we think Brexit actually means, what we think the people have actually voted for, and that for me is a much better democratic impact, and I think it's much more likely to be achieved through political means. Thank you very much.
So next up is Pavlos Eleftheridis, who's the Associate Professor of Law specialising in EU and jurisprudence and a Fellow at Mansfield College. And he's going to include within his presentation the question about the end process and whether you need a second referendum at the end of the process.
So thanks very much for the invitation. My own contribution to the blogosphere was a blog post on the Oxford Business Law blog on the legal requirement for a second referendum. So in my view, the European Union Act 2011 makes it legally obligatory to have a second referendum. Why? Because it says that any new treaty between the UK and the EU that meets certain conditions of substance, which almost certainly it will, has to be ratified after a referendum. Now, under Article 50, the agreement, the withdrawal agreement, will be such a treaty between the UK and the EU, and it will replace the position of the UK in the EU, and replace the treaties as far as the UK law is concerned. So that's my sort of legal view, that under the current EU Law Act 2011, which of course the government can repeal, any new agreement under Article 50 with the EU will have to be approved, the new Brexit deal, by a referendum. So that's one element of constitutional instability, because that's not what most people accept. But I think there are other issues of constitutional instability that are more fundamental. And that question is how to undo the effects of EU law over a period of 40 years. Basically, what EU law has done is to create a layer of higher law that was unconditionally accepted by the courts, by legal scholars, as having some sort of higher power over Parliament and over ordinary law. Now, once this is removed, we're basically then faced with the constitutional question. Now, what's going on in UK law? The constitutional orthodoxy, and you can see Dicey there, is that all acts have the same value because they're created in the same way by the same Parliament. And because their value and validity depends on the sovereignty of Parliament, they'll have the same value, the same validity. And that's why later ones prevail over earlier ones. Now, this doesn't fit very well with the EU law model, because EU law is based on the continental and American system, where we have constitutions as higher law, certain basic principles that Parliament cannot interfere with. That's the traditional view of EU law, and the uniformity of EU law couldn't have worked otherwise. Now, to accommodate the EU position, we've had constitutional heresy originally offered by Sir John Laws, as he then was, in Thoburn, where he said there are constitutional statutes. He didn't quite explain how they're created, but he said they exist, and the European Communities Act is one of them. And it cannot be impliedly repealed. So acts that are contradicted will have to be set aside. This view was heretical when it was first expressed, but now it's the unanimous view of the Supreme Court. Under the HS2 judgment, you've seen the reference there at the bottom, there are indeed, says the Supreme Court, constitutional instruments. And the European Communities Act is just one of them. The Human Rights Act is another, Constitutional Reform Act 2005, and in addition, that's the most interesting from a constitutional theory point of view, the common law itself recognizes certain principles as fundamental to the rule of law. That couldn't be any further from Dicey's, in my view, entirely obsolete dogma. So that, for me, that's the new orthodoxy, I suspect. However, now, we now face the prospect of a process of constitutional change as EU law is removed from our books. And in addition, and perhaps by coincidence, I don't think it's a coincidence, the Human Rights Act is also under review and will probably be repealed. And the Conservative Manifesto says something which suggests a deeper constitutional change, namely unhappiness with the view that there are constitutional instruments that could be taken to be higher than ordinary acts of parliament. So it says, Britain first, in future the UK courts will interpret legislation based upon its normal meaning and the clear intention of parliament. Now, I may be interpreting this, reading too much here, but there are other views, Lord Sumption and others, who've suggested that's the way we should go. Now, the question I want to ask is not whether this is a good plan or not, but we don't know how to get there. Because how are we to abolish the distinction between constitutional statutes and ordinary statutes? Are we going to do it by an act of parliament? Wouldn't that itself be subject to the distinction? What if we started picking out all the constitutional statutes, one after the other, EU Act, Human Rights Act, repeal them all? Wouldn't that leave us with a common law basis for deeper constitutional principles, which might offend our political masters, because they want Parliament to be absolutely sovereign. So the point I'm trying to make is not, I mean, my view on this perhaps is well understood among the people in this room, but my view is that we don't actually know what is the appropriate process whereby to sort out these fundamental constitutional questions. And since 1649, we haven't enacted an act of parliament to fundamentally change the constitution. That's the act declaring England to be a commonwealth. It's a particular act that I like very much. Since then, we have more or less constitutional stability. That era of stability, in my view, ends by trying to sort out the constitutional landscape of the UK, not over a long period of organic growth, as it has been happening in the past, but by way of a radical constitutional change, we faced with really serious constitutional dilemmas. Thank you very much.
So next, Mark Friedland, Emeritus Professor of Employment Law and a Fellow at St John's College.
That introduction makes the point that I'm not primarily a specialist in constitutional law, and in the classic judicial phrase, there is little that I can usefully add. But I'm taking this opportunity to describe work in progress on a paper headed "A Pause on the Road to Dystopia?" query, and an argument which points out the constitutional shortcomings of the European Union Referendum Act 2015 and suggests that those shortcomings need to be remedied by recognizing a certain duty on the government in pursuing the consequences of the referendum vote, which I identify as a duty of co-decision or co-resolution with Parliament and the devolved authorities of Scotland, Wales and Northern Ireland. If we pose the question, in what way was the referendum set up by the European Union Referendum Act 2015, the answer has to be that it was constituted with deep and conspicuous disregard for the legal and constitutional consequences of its outcome. The Act quite simply and starkly provided in Section 1, subsection 1, that a referendum is to be held on whether the United Kingdom should remain a member of the European Union. As to the fundamental question of the status and effect of the voting outcome, as to whether and if so in what sense any particular majority was to be regarded as decisive and binding in any particular circumstances, not a single word was said in the Act. This enormous failure of clarity was to a certain extent explicable in the particular political circumstances of the moment, but can nevertheless be regarded as a major abnegation of responsibility on the part of the government, the opposition, and the Parliament of the day, and has certainly turned out to be fraught with difficult consequences. In particular, the Act left a deep-seated problem about the United Kingdom's submission to the Article 50 process. It gave rise to all the doubts which have manifested themselves about the inevitability or conditionality of the progress from the referendum vote to the actual withdrawal of the UK from the European Union. Those doubts arise in relation firstly to the triggering of the Article 50 process, and secondly as to the finality of that process once it has been embarked upon. A spectrum of views has emerged to fill that vacuum. At one extreme is the view that the referendum vote was absolutely decisive, so that it should lead automatically to a formal triggering of the Article 50 withdrawal process without more ado. At the other extreme is the view that the referendum vote was advisory or consultative, simply requiring Parliament to decide whether to legislate for withdrawal in light of the information provided by the vote. The possible and declared viewpoints can be grouped into, on the one hand, a view of the post-referendum process as a prescribed and mechanical one, or on the other hand, as a guided but still deliberative one. Answers to that question had been left grievously undetermined by the 2015 Act. Crucially unspecified and undetermined is the question of what, if any, approval or ratification or enactment of the decision is necessary on the part of Parliament itself. That last question will require a very difficult operation of construction of the legal and conventional constitution to resolve it. That latter point evokes a still deeper problem which confronts the government during the present and succeeding phases. It seems very likely on the present showing that the Prime Minister will proceed through that present phase on the footing that her government is entitled to trigger Article 50 as a matter of prerogative or executive authority and or implicit delegation from Parliament under the 2015 Act. In this sense, there might appear to be a viable path through and out of the present interim phase. However, this confident presentation marks a particular tension between the referendum phase and the subsequent phases, a profound functional misfit between the 2015 Act and the Article 50 process. This problem, in a nutshell, is that the process implicitly envisaged by the 2015 Act, if the referendum vote was for Brexit, could only work satisfactorily if the general form and consequences of Brexit were known and determined before Article 50 was triggered. But Article 50 itself envisages and provides for a process in which even the broad outlines of the consequences of withdrawal are not known at the moment when Article 50 is triggered, but are left to be determined by a subsequent process of negotiation. Therein lies a truly dystopian quandary. The government seems determined to trigger Article 50 early in next year, regarding itself as having full authority to do so, and the opposition does not seem to offer meaningful resistance to that intention. It therefore seems most likely that this dystopian quandary will have to be resolved, so far as it can be, in the subsequent phase during which the Article 50 process will be taking place. This demands that we look for a constitutional doctrine or approach which is adapted to the rather singular continuing challenges which it presents. I argue for a constitutional idea of co-resolution which might provide a guide to the meeting of those challenges. We are now seeing considerable polarisation around two kinds of possibility, two broad positions in favour of hard Brexit and soft Brexit, respectively. This appears to increase a tension between the government on the one hand and Parliament and the devolved authorities on the other, since many of the members of Parliament and of the various devolved authorities, among whom there were previously majorities for remaining, might now be predicted to be preferring softer Brexit positions. Beset by these tensions, the government might find itself increasingly at odds with Parliament and the devolved authorities, and increasingly inclined, as the going gets rough, to regard and castigate them as unfaithful to the will of the electorate, as expressed in the referendum vote. In this difficult situation, I think it will be crucial to secure a high degree of consent and coordination between the government, Parliament and the devolved authorities, especially given the crucial roles which Parliament and the devolved authorities would have to play in the implementation of the outcome of the Article 50 withdrawal process, whatever that outcome might turn out to be. We should therefore make every effort to derive from the basic principles of the United Kingdom Constitution a normative approach to the governmental conduct of that process and the execution and management of its eventual outcome, which would minimise these prospects of constitutional fragmentation. A suggested approach would consist in...
Mark, stop now.
Actually, stop.
Stop. Well, I mean, just come to a conclusion.
Yeah, absolutely to conclusion. A suggested approach would consist in the articulation and development of a set of obligations of co-resolution or co-decision between these constitutional parties, in particular a duty of co-resolution upon the government, which would operate as a constraint upon its prerogative or executive powers in the conduct of the withdrawal process. Such mechanisms of constitutional cohesion will be crucially needed and severely tested if, for example, the matter of Brexit should reach a critical point where the revocability of the now eminently likely decision to commit to the Article 50 withdrawal process comes up for reconsideration. Thank you.
So, finally on this half of the programme, Steve Weatherall, who's the Jacques Delors Professor of European Law here at Oxford and a Fellow of Somerville College.
It's sometimes said that the government has no understanding of the full implications of Brexit. It's not true. Here's a document published only 7 days ago which shows a deep understanding of the implications of Brexit. Okay, the government that's produced this document is not the British government, it's the Japanese government. But okay, someone knows what's going on. What is Brexit? Brexit means that the UK leaves the European Union. That means that the UK is no longer a member of the European Union. The UK will then join over 160 states around the world which are not members of the European Union. It would exaggerate to say that there are more than 160 models for a relationship between a state that's not a member of the European Union and the European Union, but it wouldn't exaggerate by much. You can have a model where a state that's not a member of the European Union has a rather intimate relationship with it and takes on much of the acquis communautaire. You can have a relationship based on a free trade area. You can have a relationship based on the WTO, plus sectoral agreements. You can have a relationship based on the WTO itself. You can have a relationship not at all. You can have a relationship stretching from Norway to North Korea. The UK will fit somewhere on that spectrum, I suppose. There are three core choices that need to be made in order to determine where the United Kingdom falls on that spectrum from Norway to North Korea. First choice, external. Most concretely, will the United Kingdom remain within the customs union? If it does, then goods made and manufactured in the United Kingdom will be able to gain access to the rest of the European Union market, economically advantageous. But the UK will not have the capacity to develop its own trading agreements with the rest of the world. Vice versa, if the UK claims the rights to these external trade opportunities, it will in some way, to negotiate it, lose access to the EU's internal market. Second set of choices that need to be made relates to the relationship between the UK and the EU itself. The EU's internal market is a package of rules which control trade barriers and establish common standards. Well, the UK is going to have to decide which of those rules it'll sign up to. The more it signs up to it, the more burdens it takes on, the more benefits it can claim. The fewer burdens it wishes to shoulder, the fewer benefits it will enjoy. The Japanese document is very strongly pushing the UK government to remain within the customs union and to sign up for all the rules of the internal market on the basis that successive UK governments have promised Japanese firms and the Japanese government that that was what would happen. An inward investment, potential inward investors the world over are making these sorts of calculations right now and scratching their heads. The third area in which choices have to be made are internal choices. How will the UK adapt its legal system insofar as it is no longer obliged to follow the rules of the European Union? That doesn't need to be decided overnight. It could be decided over a long term, although the choices available to the UK will depend on the choices made at stage 1 and stage 2 with regard to external trade and its relationship with the European Union. So, choices have to be made. First of all, by the United Kingdom, there will be blood on the floor as these choices are made within the United Kingdom government, because different people have very different visions and have made very different promises through the course of the referendum campaign and since. Once the blood has been cleaned from the floor, the UK will then have to negotiate with the European Union. But whatever choice is made, whatever deal is struck with the European Union, there won't be a mandate for it from the referendum. The referendum gave a mandate to leave, but that left wide open the sort of leaving that would be involved, which is conditional on the choices that I've outlined to you, the three types of choices. This, of course, was the calculated strategy of the Leave campaign. They avoided presenting a particular vision of what leave would mean in order to be able to put forward a whole range of different promises, some of them mutually irreconcilable. That's why Leave won the war. That's why we don't now have peace.
Right, so at this point, we're going to open it up for discussion on these general constitutional issues. We've got 10 minutes possible discussion. You're going to have to keep your points very sharp and quick. I've seen one at the back. Have we got a roving mic? Sorry? Yeah. So there's 1, 2, 3, 4. Yeah.
Thank you. To Nick, if I may, you said, would the judges dare? or words to that effect. The judges wouldn't dare. From the EU law point of view, I'm just concerned about whether the judges at the Court of Justice would surely have to have a role if it's the phrase constitutional requirements or whatever constitutional arrangements from the treaty that we're talking about, then only the judges at the Court of Justice have the competence to interpret that phrase. That's the point for discussion.
Okay, thank you very much. Good point. Can we... Yeah. Roy? Yes.
I don't understand why triggering Article 50 has the slightest impact on the European Communities Act. It manifestly doesn't. That could only be done by repeal. I don't understand why the situation is different from any other international convention that we sign up to. We generally introduce legislation first to ensure that we get it through. But why is it different when we're dealing with an agreement with the European Union?
Thank you. Person in front.
Yes, Olivier Benet, I'm the president of the European movement in northern France. I had a question more for Alison. You spoke about mutual agreement of the fact that there must be a mandate by Parliament to launch Article 50. Does it mean that the EU could refuse to consider Article 50 as launched if there was just a government decision?
Okay, thank you. And two behind you.
Thanks very much. So it kind of follows from a question about Article 50. So can the UK withdraw its notification based on some later expression of public will? So if we end up triggering Article 50, whether with or without Parliament, and a general election occurs, and there's a majority of Parliament, majority in Parliament of parties that said in the manifesto that they want to reverse.
Okay, Alison's going to...
Okay. I'll very quickly cover these as best I can. The Article 15 meaning of constitutional requirements, I'm not necessarily so sure that the European Court of Justice is going to be thinking that it needs to understand what the constitutional requirements are for the UK. I think where the Court of Justice of the European Union may need to get involved is a lot of the legal arguments depend on whether you can or cannot revoke Article 15 once triggered. And I think that is an issue for the Court of Justice of the European Union. And if I wanted to buy time as the government, I would raise it as a preliminary reference issue and get it sent up. So I think that is an issue for the ECJ. I don't think they would want to say that the constitutional requirements in the UK is an issue for the ECJ. Do I think, why is it different? I agree, it isn't. This is why I don't understand the conflict either. You have the legislation to implement it afterwards. It's a later stage that we're having these arguments about how you deal with ECA, not now with regard to Article 50. So I agree with you. Could the ECJ, could the other European countries have a go at the UK because we haven't triggered Article 50 and we must, because it says we shall trigger Article 50 once the constitutional requirements are met, and etc. I don't think that the referendum per se matches that requirement, so I don't think the other EU countries could bring an action and say, no, you must trigger it. I think we have to wait until we know we've fulfilled our constitutional requirements, and we don't know what they are, so I don't think we're going to get any pushback from that yet. What about, can we revoke it? I'm with Paul Craig, so I think you can. I know that's controversial because there's nothing in there that says you can, but I think if I was a Court of Justice of the European Union, and if I was the UK and I'd gone to the European countries and said, look, we've had another election and actually we've changed our mind, what do you think? I think it'd be very unlikely that they would say, no, bye. And I think if I was the Court of Justice of the European Union and I was faced teleologically with a country that had said, look, we've just had a referendum and it now wants to remain rather than leave, and the time is not up and we haven't got a withdrawal agreement, I think in those circumstances they would be likely to let us change our mind. But it is controversial, but that's where I would be. Nick.
Do you want to? Sure. Yeah, I think that might work.
That might work.
Yeah.
Well, I can probably articulate. Should the judges in the ECJ have a role? I think not necessarily. So it could be the case that the British courts send a reference up to the European Court of Justice about the inevitability of Article 50. If they did, that would mean that the decision would be a long time in coming back. But I think that the British judges could also say that the issue was clear and that there was no need for reference, and that the real meat of the issue revolved around British domestic constitutional law and it wasn't needed. So possibly yes, probably no. Can you withdraw from Article 50 once you start? No! If you look at the text of Article 50, it's very clear that it's set, it's constructed as a cliff. I actually did some research. We looked into this. When it was designed in order to deter people from making a reference. And it's done in such a way as to give the balance of negotiating power to the community institutions who can say, if you don't reach agreement with us, then at the end of 2 years, that's it. You're out, you're on your own. So there is an inevitability to it. Sure, they can postpone the inevitable, but it is only a postponement. Article 50 was, in one sense, it was presented to the good folk of Europe as being a way of protecting states' rights to leave. But in fact, it made leaving much, much harder.
I agree with Nick.
Yeah. If only I heard that more often. But this also goes to Roy's point. So you trigger Article 50, that is in effect the same as leaving the European Union, which means all of those European rights that people presently enjoy through statute will inevitably disappear. And I'd encourage people to go and have a look at Fire Brigades Union, because I think the case that's going to be before the courts in a few weeks' time is actually much stronger than the Fire Brigades Union case. You remember that in Fire Brigades Union, the prerogative was used to change the existing scheme that compensated victims of criminal injury rather than introducing a statutory scheme to compensate victims of criminal injury. The statute was left unaffected. Indeed, the minister could have used the statutory scheme the following year or 2 years' time. But because the minister was using the prerogative to undermine the statute, to deprive the statute of effect, the House of Lords found that the prerogative was improperly exercised. The case before us is much, much stronger because you are of necessity stripping and don't forget the European Parliament Act. If you trigger Article 50, you deprive people of their right to elect people to go and sit in the European Parliament. I suppose maybe you could run the argument that we could run the elections, people could vote, and then we'd send our MEPs, send Nigel Farage off to Europe, where he'd sit and do nothing like he has been doing for the last how many years. But it seems to me to be a fundamentally unattractive argument. I will stop there, though I could keep going for a good long time.
Okay, is there any further question anybody's burning to ask on the constitutional or general issues? It's got to be really burning at this point. Okay, if a burning point.
Couldn't Alison and Nick both be right if the other 27 countries agreed to allow postponement for 1,000 years?
I'm not really sure what to say. I mean, they can agree for postponement as long as they like, so you can just keep postponing if they want, yeah. So, yeah.
There are ways to solve this de facto. Sweden is obliged to join the euro, but everybody accepts that de facto this will not happen.
Yeah, absolutely.
Okay, the article that Alison just referred to, which may be something that not everybody is familiar with, is Paul Craig's piece called Brexit, a Drama in 6 Acts, which is available on, well, just put it into Google, but SSRN. And the legal implications are, in my uneducated view, brilliantly set out at pages 28 to 42. And Paul Craig certainly takes the view that there is the right to unilaterally withdraw, having triggered Article 50. But I'm hearing that, for example...
It's open, it's controversial.
It's controversial, I'm told. My understanding was that Paul Craig was saying that, but anyway.
But he is saying
Yeah, okay, yeah. Oh, that is what he's saying, yes. That is what Paul Craig is saying, but I'm hearing that other people don't agree with that. In particular, Steve doesn't appear to agree with that.
I don't agree with that either.
Yeah, okay. No. I know you don't agree with it. Okay. We're now going to move to the second part of this, where we each take a specialist area. And first up is Luca. Are you okay to go? Luca Enriquez, Allen and Overy, Professor of Corporate Law, Fellow at Jesus College, who's going to be looking at financial services and company law, I believe. Thank you.
Yes, thank you. So, first of all, let me remind you that I'm here to fill in for John Armour, who unfortunately couldn't make it, and he was really keen to share his thoughts with you. That's why we decided that he would send me his notes, and I would work on them. Actually, what I will do is to give you an anthology, because these notes would require me to be here for at least 10 minutes. So I will cut half, more or less, and insert a few glosses of my own. So let's consider first, I will talk about financial services and company law. Financial services, here the issue, of course, is passporting. So it's a fundamental principle of EU financial services law. If you're authorized in one member state, for example, the UK, you can do business throughout the EU without any further regulatory approval. And as you know very well, Japanese and US banks have chosen London as their hub to do business within the EU. The passport now covers practically all financial services, and therefore it's big. If it were entirely removed, non-UK other member states could require English financial services firms to seek for approval, and that's the situation the Swiss are in, and that creates a lot of problem for their financial industry, which is unable to sell their products throughout the EU, and they are desperately trying to get a financial services agreement with the European Union, so far unsuccessfully. Note that they are inside the Schengen area, so free movement of people, even more than currently is the case in the UK. So what is the likely effect of Brexit on passporting? If we can't yet rule out a soft Brexit, then nothing much will change. You may end up within the European Economic Area. You will still subscribe to the 4 freedoms, but it will not be exactly the same, because you will lose the seat at the table. The rules will be made in Brussels without the UK officially sitting and voting on those rules. And that may be quite bad. Quite bad, if I may, also for the quality of EU financial regulation altogether, because the UK's input has historically been very important. The City of London is where a number of financial markets and there's no other place in Europe which has them. So most likely people in policymakers in Paris, Berlin and Brussels will have no clue of what they will be doing when they will regulate those markets, which can be good for the quality of regulation. If a hard Brexit will take place, then the British financial institutions will lose access to the internal market, to the EU market, and according to estimates, loss of access to the single market would cause a loss of 20% of the city's revenue, which translates into minus 2.5% of UK GDP and tax revenues per year. There might be the possibility of using a so-called third country passport framework if the Commission judges that the country has an equivalent regulatory regime. Firms may be authorized to do business within the EU. One might have a passport, but that only applies to transactions with professional counterparties, not for retail investors, and it is piecemeal in scope. It only applies to specific areas. It wouldn't be general. And an example of a sector which would not be covered by this regime would be the retail marketed investment funds, UCITS, which is a huge industry for the UK. It's a huge industry in Europe, including in Dublin and in Luxembourg. What I would like to note here is that UK retail investors would also lose, most likely, access to a number of EU funds that are currently marketed within the UK, which would make the market for these products in the UK less competitive and arguably worse from the point of view of British investors.
Luca?
Yes. How? Stop? Okay.
Yeah. I mean, any crucial final point?
I have a point on companies that are set up in the UK and do business in Europe. They may lose the right to be recognized as such, and my point here is that no one will take care of them in the transition, because the member states will be happy to cease to recognize them. There is no lobby that will be in place to deal with the problem, and there will be no hostage to exchange. Unlike with individuals, there are no people from the EU which live, no corporations from the EU which do business in the UK, and therefore they may be lost forever. They will have to reincorporate as European companies. Thank you.
So Anne Davis is Professor of Law and Public Policy and the Dean of the Law Faculty and a Fellow of Brasenose College.
Thanks. So I can do this in 5 seconds, not 5 minutes. I have no idea. But picking up from where Steve left off and being slightly more serious, it's really going to depend, for the purposes of labour law, which is what I'm going to talk about, on what sort of relationship we end up having with the EU after the UK has left. So the Norwegian model includes significant elements of EU labour law. The North Korean model, not so much. And of course, access to the internal market is highly relevant to the impact of Brexit on labour law, because quite a lot of the EU's influence over our labour law and labour market regulation comes from that source and not from things that you would necessarily identify from the treaties as being EU labour law in a sort of narrow sense. So what I can tell you a bit about is the influence that EU labour law has had over our law over the past several decades. And the sort of simple view would be that EU labour law is highly influential in a sort of law on the books sense. So only pay, freedom of association and the right to strike are excluded from the EU's legislative competence, and very few areas of labour law are not significantly touched by EU directives. Of course, there are some things that are very much aspects of the common law, definitional questions around the contract of employment, which many of us here in Oxford work on, the national minimum wage, unfair dismissal law are examples of statutes which are UK-derived statutes. But as I've said, EU law also influences labour law in other ways. The internal market law is very significant in that respect. So free movement of workers I would regard as an aspect of labour law broadly defined. Freedom of establishment has significant implications for trade union rights, and freedom to provide services has given us the wonderful Posted Workers Directive, which is the subject of much controversy within our field. I think there might be a more subtle view if you looked at which bits of the law people actually make use of in practice. There are some examples of EU labour law that we've faithfully copied out into English law and then ignored completely. The information and consultation of employees regulations is a really good example of that. But there are other areas where we've really engaged with what's come from the EU, and you get a much more kind of blended implementation, and I would pick out the Equality Act as a good example of that, and unravelling that relationship will be much more complex. So to sum up, although there's quite a lot to criticise in EU labour law, and I've somewhat built my career on doing that, there's no doubt that we've had more labour law from that source since 1972 than we would have done from the UK Parliament, and I would apply that comment to governments of all political persuasions. So in terms of future prospects then, I think the fate of our labour law is a matter of political choice, and so it's going to depend on the political preferences of the government of the day. Some of the things that I've been talking about, of course, implicate fundamental rights. The Equality Act is a good example of that. I hope that isn't something that we're going to lose. But even fundamental rights have an uncertain future in this country, so it's very hard to know where we're going to end up. I have no doubt that a government that is committed to showing that Brexit means Brexit will want to repeal some bit of EU labour law as it applies in this country in order to demonstrate that Brexit has indeed meant Brexit. And I'd pick out the working time regulations as a very likely target for that. And I just want to conclude by commenting briefly on the impact on EU labour law itself in the absence of the UK. And I think that's also an interesting area of inquiry. On the one hand, there won't be the sort of UK constant resistance to any new measures in the field of labour law, so it'll remove a kind of blockage on future legislative development. On the other hand, having a noisy neighbour with a significantly deregulated labour market might create some sort of downward deregulatory pressure on the rest of the EU. So upshot then, the future very uncertain, I think, in my field, and both for what will happen domestically and what will happen within the field of EU labour law itself. Thank you.
So Graham Dinwoody, Professor of Intellectual Property and Information Technology Law and Fellow of St. Peter's College.
Thanks, Andy. The implications in IP are going to vary across the different forms of IP because the different forms of IP have Europeanized over the last 40 years at different speeds, using different instruments and through different institutions. So what I'm going to do is basically pick 1 minute on each of the four and try and make a couple of comments about each of them. So let me start with copyright law. Our national law is being increasingly shaped by what is now 11 different piecemeal directives in copyright that the Court of Justice has managed to expand to what some people might think a very large chunk of British copyright law. And the question of whether or not there's been any change post-Brexit, I think, is really, given that those have all been reflected in our domestic copyright statute, other than some of these small interpretations, gets really to Steve's internal choice about whether or not the British courts decide to interpret European-inspired legislation with an eye to what the Court of Justice has done and to what the Court of Justice will do in continuing to interpret those instruments for the other 27 member states. Legislative, I moved, depending a little bit on Steve's external choices, the models that are picked. You may think that relieved of the copyright acquis, which is now getting quite substantial, Parliament could return to questions such as personal copying exceptions, which was struck down last year's Section 28B, or rethink exceptions more generally, where the Brits have on the whole been unable to go as aggressively as they wish. But I think Brexiteers who think that we've regained autonomy in copyright policy, and I grant you that's not the reason for 52% of the vote, I suspect, but those people are going to be disappointed. And the reason they're going to be disappointed is these wonderful free trade deals that we're about to do with the rest of the world, every one of them will come with a very, very detailed intellectual property chapter. Every one over the last 15 years has been heavily at the center of free trade deals, and they have effectively put together some form of softer but higher law that will constrain what our choices are. If you just want to summarize and maybe caricature what this, they basically say comply with EU law. So I don't think we're going to get much more autonomy. What we'll lose, I think, is European copyright law, because in picking up a little bit on Luca's comment, I think, in fact, the United Kingdom has been one of the more sensible breaks on the continuing expansion of copyright owners' rights, and that is going to be a loss when we leave. Trademark law, somewhat the same, except that trademark laws are substantive national trademark law is almost entirely reflective now of the trademark directive, same questions as copyright. The more interesting questions in trademark arise with respect to the CTM, or now the EUTM, which is a unitary right covering all 28 countries. So that will shrink to 27 countries, which raises two sets of problems. First of all, the protection of rights in the UK post-Brexit that were covered by the CTM, but that will no longer be covered by the CTM. We've been telling British producers for 20 years, get rid of your national rights, should be protected by the CTM, and now the CTM just shrinks, it doesn't cover Britain. What do they do? Well, we could actually force them all to apply, which would give it a lot of work at the UK Intellectual Property Office, or we could automatically convert all of them to cover and be national registrations. It's possible, because they probably aren't prior British rights, because of rules in the CTM system, but that would result in huge clutter and deadwood on the register, which we already think we have a problem with, so not exactly an easy choice. Secondly, what about UK producers who hold a CTM but have used the mark only in the United Kingdom? Will they become vulnerable to revocation for use of their CTM because they were only used in one member state post-Brexit. That is a serious issue, though interestingly it's a rule that the British courts had almost been getting to before the British voters in a couple of cases, when basically they said use in the United Kingdom is not necessarily sufficient to maintain the EU right. But I think what we're going to get there is a transitional period that will allow British producers to maintain the CTM with the registration with some use in Europe. Maybe it's a couple of years of a transition period. Some of the same issues that arise in trademark arise with respect to design, which also has a unitary right. The conversion issues will be roughly the same. I think what you will see is this stop in a motivation to repeal, which was on the table, British unregistered design right, because now that we've lost European Union unregistered design right, we need the British equivalent. Finally, there's patent. As to existing substantive patent law, the implications are relatively slight because we have almost no substantive EU patent law. The core of the European patent system is not a creature of EU law, but a creature of a convention, international agreement, the Munich Convention. And the system under the EPO is already includes member state contracting parties who are not member states of the EU. So we can continue with the EPO regardless of Brexit. Instead, the implications in patent are real, but they're real in the context of procedural innovation because for decades we have been trying to get a unitary EU patent that would allow enforcement throughout the European Union, and Brexit may derail, or very least require substantial renegotiation of the planned unitary patent. It had been hoped to put that into effect in 2017. That will not happen. It would have allowed you to get relief throughout the whole of the EU, but that no longer will include Britain. And so therefore, at least from the British perspective, that's going to be a big change. But it's even more significant than that, because ratification of the agreement required 13 member states and Britain, France, and Germany to ratify for the system to go into place, even for the other countries. What's more, to complicate the politics, one of the central divisions was going to be based in London. It's an interesting political paradox that we'd have a court in London that actually was adjudicating on the protection in every other member state, but not in the United Kingdom. Interestingly, therefore, you see the ratification problem is such that our withdrawal may be such that the entire system for the other member states will not go into effect. Interestingly, and I cannot know why, David Davis' Brexit questions, if that's the right term for what they had on Monday, suggested that we might ratify it anyway, just for the hell of it. It was all I could see. I don't think there's any clear sense of direction of why they should do that, so I guess in IP the question is it's a pretty mixed bag.
Next is Liz Fisher, Professor of Environmental Law and a Fellow of Corpus Christi.
Okay, I want to say three things. I want to say a little bit about environmental law. I want to say a little bit about what might be the possible consequences for environmental law of Brexit. And I want to finally end on what I think we should, as scholars, be contributing to the debate. So to begin with, environmental law is the law of environmental problems. And I think there's a temptation for non-environmental lawyers to think either of us as kind of hippie types, laughter in the room, or just to think, actually, this is a subject about environmental quality and it's just instrumental. It's just about rules which are designed to protect the environment in certain ways. But as the sessions in the subject group have been going over the last couple of days, what it makes clear is that environmental law is thinking about what kinds of rights, obligations, and processes are needed to be embedded in law and fleshed out. So if I take Maria Lee's work on what kind of knowledge claims are real knowledge claims in planning inquiries, Colin Reed's work paper at this session talking about what kind of rights are information rights, and so on. So it's a thick legal subject. Okay, so what are the consequences of Brexit, whatever it may mean, for environmental law? Most UK environmental law has its source as in EU environmental law. And in part, that reflects perhaps the fact that it has been a sort of ideological force for a high level of protection, but it also just reflects the fact that EU environmental law took off in the 1970s at the same time that environmental law took off in most other jurisdictions. Most environmental law, EU environmental law in the UK is in the form of legislation and delegated legislation. So whatever Brexit may mean, whether it means North Korea or Norway, if we leave, that law will remain. And so nothing will happen overnight. And while I like being optimistic, I'm not particularly optimistic about what will happen. And there are 3 reasons for that. First of all, a number of the Leave campaigners were pushing a deregulatory agenda. They liked the idea of free movement, but they didn't like the idea of regulatory red tape. And environmental law came into that area. So that's my first reason. My second reason why I'm not optimistic is that EU environmental law has not just been about putting it into national law. It's been about the interplay between our national legal culture and our national legal order and EU law. And what that interplay has done is develop the thickness of EU law. And I would just note some of the key cases in the Supreme Court in recent years have been environmental law cases. HS2, Walton, Champion, Evans. These are all cases about the nature of environmental law norms. And leaving would remove that catalyst, remove that kind of process. My final reason why I'm not optimistic is the problem with all these trade deals, whatever form they may take. There is a danger of a race to the bottom. A lot of environmental law is not about product standards. It is about the environmental quality within this jurisdiction. And the temptation is to say, to be competitive, we need to deprioritise that quality. Okay, I should stress that I don't think that this process is overnight. I think it will be incremental. Nick talked about zombie pieces of legislation. In the environmental field, it's probably Nigel no-friends pieces of legislation. Just sitting there a little bit sad. No one's enforcing it. No one's really thinking about it. Okay, so what is our role as scholars in all of this? To me, the other very serious consequence of Brexit is the shift to this language of sovereignty and control. The major lesson of environmental law is that jurisdictions are interconnected by markets, by geography, by politics, and environmental law is inherently multi-level. But we find ourselves in a world where we talk about sovereignty and control, they sound very attractive. And however much we might talk about the UK's sovereign right to decide its environmental law on itself, it is bound to other legal cultures and other jurisdictions. And there's a real danger that we forget that. So it seems to me that as scholars, we have a duty to ensure that this thickness and these interconnected relationships are put on the agenda. Thank you very much.
So next is Angus Johnston, Professor of Law, specialising in EU law and competition law, and a Fellow of Univ College.
Andy, thanks very much, and apologies I wasn't here at the very beginning. So Andy's asked me to talk about competition law, and I've done a little summary table which people are welcome to take a copy of when they leave. What I've done is to try to just divide things up into a few headings: jurisdictional questions, substantive questions, procedural questions, and institutional dimensions. And I'd start by echoing what Anne said a moment ago, that you could just say, you don't really know what the competition law implications are for Brexit, because there are a lot of uncertainties that we don't really have lined up yet. You'll see, if you see the table, that I've also divided into a number of different ways we might have relationships with the EU post-Brexit. The first column relates to EU law's impact after Brexit, whatever else happens. The second is if the UK is in an EEA-EFTA type relationship with the EU. The third, some kind of access to the internal market on terms that we don't know. The fourth, some kind of free trade agreement or bilateral investment treaty arrangement, plus WTO, and the fifth, WTO. Obviously, I can't go through all the permutations in a couple of minutes. So let me just say a few things about each different area and try and give you a flavour of some of the things that might be the implications. So first of all, jurisdictional questions. EU law will have an impact upon us anyway, regardless of what relationship we end up negotiating, because there may be practices located in the UK or located in the UK and other areas which will be implemented in the EU or have effects within the EU, which affect trade between EU member states, although in the UK, and have an EU dimension in the form of mergers. So all of that is going to have EU law asserting its authority over things that we might consider, at least in part, are UK questions. With regard to other types of relationships, the EEA-EFTA scenario, I think, will be remarkably similar to what we have now, dependent upon certain specific terms on particular sectors that we might choose to opt in or out of. There's an example with Norway in the energy sector, for example, where how that links with competition law is quite complicated. And with the other areas, it really depends entirely upon the terms that one agrees in any kind of free trade arrangement, bilateral investment treaty, and so on. Substantively speaking, our UK rules after the 1998 Competition Act are, for the most intents and purposes, identical to the European rules. On the table, I've just summarised that effectively the main implication is exactly who does the enforcement and which geographic market areas might be covered, which could be EU, it could be UK, or it could indeed, to hark back to what Mark said a moment ago, be devolution type questions in sub-UK areas. Not devolution in the sense that competition law in the UK is a default issue, it's not, but because sub-markets can sometimes create very difficult political questions, which we've seen in much UK competition law over many years. The big difference that we have that is maintained and will keep being maintained is that we have a market investigation reference process, which the EU does not have and the UK will obviously retain. The key question, I think, here with regard to substantive rules is the fate and implications of our European Coordination Clause in the Competition Act in Section 50, which tries to align our interpretation and practice with that of the European institutions, particularly the Commission, and also following court decisions along the lines of indirect effect and interpretation. So it seems to me that if we have an EFTA, a EEA-type relationship, Section 50 will still be important. And in the other areas, well, we have an interest in maintaining substantive parallelism, indeed perhaps even identical rules, because the multinationals that are dealing with these sorts of questions will want compliance not to be made so much more difficult by the fact that there is this separation. And go back to what Liz said a moment ago, one of the things that we've heard about is the deregulatory agenda, and one aspect of this is going to be trying to make sure that those who are regulated by these rules understand what rules apply to them and exactly how they need to behave and what isn't possible. So I suspect that's going to be a key substantive question. The other thing with regard to substance more generally is we're going to lose some things. So we're going to lose the possibility of having a one-stop merger shop for anything that deals with an EU dimension. We're going to have potential issues of duplication, so perhaps cartel fines imposed by the UK authorities and by the EU authorities, which lead to interesting ne bis in idem questions. It might also have bad effects for leniency regimes if you don't really know exactly who to go to with what when, and it might also lead to worse deterrent effects if these sorts of things get tied up in lengthy legal argument. So there's lots of different questions there, I think, that arise substantively, depending upon the terms of whatever relationship we negotiate. Procedurally, I propose to say much less. I think I just highlight that different time limits can cause disastrous problems in this area with regard to mergers or the time limits for decisions in antitrust cases. And I think also procedurally we're going to have some very difficult questions practically about cooperation between the European level and the UK level. So we have some examples out there. The EU-Switzerland cooperation is very intense. It's apparently very, very well functioning. And really it starts to raise the question, if the UK isn't in EFTA EEA, then it's going to need some kind of cooperation competition agreement with the EU on one basis or another, including perhaps what we might call negative comity arrangements, restraining each authority from doing things that might damage the interests of the other, leading perhaps to notification of activity that would affect the other, even to positive comity for requiring cooperation for investigation, for acquiring information, and so on, like the EU has in its agreement with the United States. And more generally, there's going to be, in the absence of anything like that, a need for a lot of ad hoc cooperation. Which brings me finally to the institutional dimension. And really the crucial thing I think here is the difficult position the UK National Competition Authority, now the CMA, is going to be placed in. There's going to be questions about what role it plays in the European competition network. Already I understand it to be being marginalised in some discussion groups because of an expectation that Brexit will happen. Well, what will happen if the terms of the EEA-EFTA arrangement have specific details? What role will it have in this network? What contribution will the UK bodies, the UK rules make? Answer, it's very, very hard to tell. And that direct liaison that's going to be needed between competition authorities because of these overlapping potential issues of jurisdiction and geographic markets is going to be ever more acute the more you move away from EEA-EFTA and the more you move towards looking at free trade arrangements, bilateral investments, or simply operating under the WTO-type regime. I should conclude on that point by just saying the WTO regime on its own is clearly not a realistic scenario, as a number of other speakers have said previously. It will not be the only thing that can govern the relationship, regardless of what many remarkably well-informed, and I use that phrase advisedly, people told you in the context of the referendum discussion. So to conclude, I don't know. I suspect the answer, as others have said, is that we're going to have some rules which will endure for a long time, and in competition law there are very strong reasons why those rules will endure substantively in more or less the same form, perhaps going forward without really much change at all. Some differentiation is already there, and other bits of differentiation we decided we didn't need, and we will still have good reasons not to have that, even if we hide the fact that it has the EU label on top of it. Thank you very much.
So last but by no means least, Glenn Lutenhauser, who's the Associate Professor of Tax Law and a Fellow of St Hugh's College.
Thanks very much, Andy. I'm really pleased to be here. This might be least, actually. The tax law is quite a bit different, I think, from some of the other areas of law we've heard. And I mean, there's loads of guesswork, obviously, at this stage. But I was wondering, when I was looking at the sort of the possible effects of Brexit, it didn't seem as pervasive as some of the instances we've heard. And I came across a quote from my former tax teacher, who was the late John Tiley, the professor of tax at Cambridge. And I'm probably well known to lots of people here as a former SLS president. And John wrote in his revenue law textbook, national tax systems are truly national and are one of the ultimate expressions of national sovereignty. They are usually drawn up in the interest of the nation and not of the nation's neighbors, which in difference is, at least in common law systems, returned by the neighbors. And I think that's why if you look at some of the big taxes, the income tax and national insurance contributions, it really is, in the UK, it really is a national tax. I want to say a few things about corporate tax and also the international tax framework, because again, unlike some of these other areas of law, if the UK is no longer a member of the EU, it has already negotiated more than 100 bilateral tax treaties with its trading partners, and those will stay in place. So I just want to start with probably the most European of taxes, which is the VAT. It's the one where the UK government has the least amount of ability to modify. It's imposed by the VAT directive and also implementing legislation. So if we were to have a hard Brexit, what would happen to the VAT? Would it disappear overnight? It certainly could. Does it raise £100 billion a year in revenue? Yes, it does. So are we going to be keeping it? I think very likely something like it. And when your trading partners have a VAT that's sort of close to where you're starting, you might not want to modify it that much at all. The other interesting thing about VAT is I snuck away to a bit of a conference yesterday with some economists, and as corporate tax rates are sort of dropping and have dropped over the decades, there's more and more interest now in looking at taxes like VAT as sort of the future of taxing business. Under something like a destination-based tax. So do I think the VAT is going to disappear? No, if anything, it's probably online to become even a more prominent tax over the years. Customs and excise, I don't know much about that. I suppose you could bump up the excise on French wine if you wanted to do that. That would be tragedy. I really hope that doesn't happen. On the direct taxes, I think by which I mean income tax, corporation tax. The corporation tax has had obviously some effects on the corporation tax from EU law, although again not as much, and that's Article 115. So we have to harmonize. There is a possibility of harmonizing corporation tax by directive, but there just hasn't been much of it because it requires the unanimous consent. So there's really, what about 6 or 7 really key directives which have been implemented as well by UK regulation. A lot of those have to do with sort of head office kind of situations. So the head office in London, if it's taking interest in royalties and dividends from subsidiaries through the EU, those are generally under the current system tax-free. And if those directives were to be repealed and by our neighbors, then I think there would be some concern for UK PLC because the tax treaties would then come into play, but they're not as generous on withholding tax generally. So there would be some concerns there. The other thing I wanted to mention is the Court of Justice, which has had an important impact on corporation tax and the cross-border aspects of corporation tax in the UK. We think of Cadbury Schweppes and the Marks and Spencer's cases in particular. But what's interesting too is a lot of what the court was trying to do to break down barriers on freedom of establishment is very much in line with what's been happening internationally and the general UK policy on international tax. So for example, taxing controlled foreign companies that are resident offshore. The court was suggesting we really need to cut back the scope of those kind of rules when the company is genuinely established in another member state, and the response of the UK government was, well, that's kind of where we're going anyway, so we're just going to reduce the scope of the law generally. Again, after Brexit, I don't think we would see a greatly expanded controlled foreign company. There'd be little bits and pieces maybe of the group relief rules, that sort of thing that they might not be happy with. But again, not as much as you'd think. Yeah. Oh, sorry. And quick thing on state aid. I guess the UK would be able to do maybe some more special deals with companies like Apple and that sort of thing if they wanted to, free of state aid. I don't think they probably would want to do much of that. Thank you very much.
So we've got almost 25 minutes. Open discussion. Anybody wants to make any points or ask any questions? Okay, Louis. Thank you.
Thank you. We heard yesterday at the Law Commission session that in terms of substantive law, and I assume it means also a lot of regulation, that what is likely to happen is that a lot of EU law, or EU law that's been enacted in secondary legislation here, depending on the ECA, when we get to Brexit, will all stay where it is, and then the government over the next however many years is going to have to decide whether it wants it or not. And I mean, first of all, I wondered how much the panel agreed with that, but that was the sort of general idea from the Law Commission that they might be involved at that stage in deciding what stays and what goes, to the extent it's not a matter of policy. The other point I'd be interested to know the views of the panel. I mean, we've heard in some ways two views. We've heard the view from someone like Liz, who was saying, well, when we're looking at some kind of regulatory law, we could be in a sort of race to the bottom, a deregulatory competition. But the more optimistic view, perhaps, was what Graham said about copyright, I think it was, which is, it seems to me this must be the case for many of our trading partners, that it isn't just a question of having to have certain rules enabling us to trade with the EU, because they're mandatory. If we want to trade with the rest of the world, these are common global standards now, and they will kind of stay. There's a move towards globalization, but not just in terms of business, but in terms of standards. And so how much does the panel think those kinds of standards are really going to change? Won't we have to stick with what we've got, or something very like what we've got, if we want to remain a part of the wider global market, which will include, presumably, EU countries, because we will no longer be part of the EU.
Any other points or questions anybody wants to raise at this point? Thank you.
Just picking up on that point, but more specifically addressed to Professor Davies with respect to labour law, I wonder if you might comment on whether the withdrawal of Britain from the European Union, if it happens, will trigger what has been an extraordinary lacuna in European Union law, which is the absence of a comprehensive international, supranational labour law in the European Union. And if that in turn might provoke in the future a possible regulatory comparative advantage for Britain, in the sense that Britain doesn't advance towards that kind of system.
Anybody else want to raise anything at this point? No? Okay. Now, I'm going to take Chairman's prerogative here just to comment back on Louise's question, because I think I know a bit more than some people about the Law Commission's present position only by talking to the Chairman last night, and I don't think there's anything confidential about this. But it would seem to me that there are two levels of inquiry that we might be interested in. One is what I would call the high-level political inquiry. The other is the belt and braces legal, technical issues raised. Now, on the second of those, and I think that is the only one on which the Law Commission would have a role to play, it seems to me the question that's being asked is this: if you wanted to ensure that the present position doesn't really change at all, how can you achieve that? And I think the answer depends on which type of legislation you're actually dealing with. So in the areas I know about, I would say we've got 3 distinct types of legislation. You've got freestanding domestic primary legislation inspired by Europe, but that can just carry on without any real difficulty at all. And I give an example, the Consumer Rights Act 2015. There may be some technical issues about interpretation of good faith within that, and are we now bound in the same way that we were before by the ECJ? But basically that just carries on without anything. Then there are 2 other types of legislation. One is secondary UK legislation, which is dependent on the continuation of the European Communities Act. And it would seem to me if you take away the European Communities Act, the authority for that secondary legislation has gone. Therefore, that has to be reenacted. And the third type is the directly applicable EU regulation, which again would have to be reenacted. So the interesting issue is on the second and third types of legislation, how do you achieve that if you just wanted to reenact overnight? So let's just say we're going to reenact all secondary UK legislation and all EU regulations. Can you do that? Basically, the answer is yes, you can. A piece of legislation could just do that overnight, but there will be some problems. So to give you an example, an EU regulation exists, as you no doubt many of you will know. If your plane is delayed, you're entitled to compensation under an EU regulation directly applicable in this jurisdiction. If we reenacted that tomorrow, it would say that the flight that you have to be on travels from a member state. So how are we going to ensure that phrases like member state will apply when we're no longer a member state? There is going to be those technical issues. Brilliant for lawyers. This is the sort of thing we love. It's not the high-level political problems that really the law commissioners can't do anything on. But it seems to me that nitty-gritty question is an interesting one that the law commission and nitty-gritty lawyers could get involved in. And there are lots of those. I mean, I think, as I understand it, the Brexit people would imagine that you can do that belts and braces job very easily, and then over the next years, we will just pick and choose to take some of these out if we don't like them. So that was just my contribution on Louise's question. Did anybody else want to pick up on... Yes, oh, Anne, there was a question to you. Yeah.
I don't know if this is on. Can
yes,
you hear
it is.
Me? Yeah,
yeah.
Okay, thanks. So let me just also comment on Louise's point, and then I'll try and answer Brian's question as best I can. So, Louise, you contrasted people coming at this from the perspective of there'll be a race to the bottom, it'll be deregulatory, as against people saying, well, there are common global standards. I think I can sort of finesse that a little bit. Those of us who are saying it's going to be deregulatory, it's going to be a race to the bottom, we are talking about bits of law that in the popular perception don't benefit businesses. We're talking about labour law, we're talking about environmental law, areas that might be thought to impose costs on businesses, and that's why we're talking about deregulation, because nobody who's in a position of power to lobby the government is going to be able to lobby for those things to be preserved. I personally don't share that sort of straightforward perception that labour law is inevitably a cost on business, but that's a discussion for another day. In terms of the prospects for a comprehensive labour law for the EU, I sort of, in an altruistic way, wish that that were true, but I'm afraid it might not be. And that's because I think the sort of vibe from the EU is not very much in that direction. So even with the removal of the UK as a blockage to that kind of approach, I'm not sure it'll happen. And I'd pick out 3 reasons for saying that very briefly. So one is we haven't had much attempt to have significant new labour law measures for some years, and I don't think the UK can be the only explanation for that. We haven't seen the Commission attempting to propose new legislation for some years. There has been significant deregulation of labour law in a number of member states as a result of the bailouts. So that's another one of the ways in which EU law influences national labour law in a way that isn't through EU labour law at all. So if you look at Greece, for example, they've been told to cut their minimum wage, raise the retirement age, reduce the level of collective bargaining, and so on. And a thing that is quite interesting to have a look at is the Commission's document earlier this year on the European social pillar, which is meant to put a friendly social face in the Eurozone, but I suspect if you read it carefully, it's more style than substance. So I wish you were right, but I'm not sure it will turn out that way.
Liz,
Can I just come back to your belt and braces, because I also...
Do you want to take the mic? Yeah.
Oh. The belt and braces point, which is that a lot of the substance of EU environmental law is not in the regulations, it's in the case law. So there's another technical question, is what happens when we leave? What counts as precedent?
Yeah.
You know, the question of what is waste. Very exciting.
Yeah.
What is the significant effect? These have been shaped by the interplay between the Court of Justice.
Yeah. Well, it's the same as the good faith question that I was talking. I mean, I assume the answer is we're going to have to trust the judges to work this out. They were bound at the time at which the EU laid down, the ECJ laid them down. They're no longer bound, but my guess is they will consider themselves partly bound and partly not bound. In other words, they can do what they like. But yeah, there's a really interesting technical question there. I'm going to take another question from over here. Can we have the students on the toes, please? Come on.
Thank you. I just want to add another category to your problematic categories for belt and braces. And that is where the EU legislation or the domestic implementing legislation itself refers to standards that are produced through currently EU-led institutional arrangements. And this happens in lots of areas. Environmental law is one that I'm exercised with is pharmaceutical standard setting and clinical trial standard setting. So sometimes those institutional arrangements also interact with global standards. So we really need to know the answer to Steve's 160 models before we can begin to think how could we possibly plan a belt and braces, turn a switch overnight and keep it the way it is?
Do you mean it's legally impossible to just draft something that would immediately put into place, or it just make no sense if you did so?
Is it legally impossible, or would it make no sense if it did so? I'm sorry, my law in context head finds it hard to answer that question.
Oh, okay. Right, I'll shut up then. Anybody want to say anything about that at this point? No? Interesting observation. So there may be other categories that we need to look at as well. I think there is a real issue. I'm just pretending you're the draftsman who has to do this, right? I think they're just going to be asked a technical question. Just do it. Don't worry about whether or not down the line there may be some potential inconsistency and so on. There are some upfront inconsistencies that no drafter could ever deal with. But I think there are some that maybe one could just get round by clever generic drafting. I may be wrong about that. But you're saying that's an area that is problematic because it would be unclear what's being implemented. Just to add it to your list. Yeah, okay. There's another question there, and then Rob, Stevens, and here. Okay, let's take them all together. I'll just go from left to right.
Okay, so my question is about equivalence, so I imagine Luca will be most interested in it. But so equivalence is something that a lot of people have said we should rely on with respect to passporting specifically. And so I wondered if you had any views on the political possibilities there, or whether it would be politically impossible. And then also on the potential risk of future EU legislation after withdrawal, making equivalence quite risky. So I wondered if there were views on that.
Okay, next, Rob.
My point is about Andy and whether or not this can be solved by clever drafting, so that I would have thought that there are at least some rules. The most obvious one is the Brussels I regulation, where the rules are predicated on our membership of the European Union. So it can't be that we can just circumvent the problem by clever drafting, in the sense that the whole point of recognition and enforcement of current court judgments is the quid pro quo aspects of it, which is to say, we get recognition of our judgments in Greece because Greek judgments get recognition here. We can't, just through clever drafting, recreate that position with the Brussels I regulation and presumably many other regulations.
I agree with that entirely. Yeah, there are some, obviously, provisions of that kind. I agree with that entirely. Who was third? Yes, thank you.
It's just to say that I don't think these are little technical questions. So to pick up on Tammy's point and Liz's point, and it's similar to Rob's point, these are really deep governance structures by which we make value judgments and substantive judgments on the world we want to live in. It's not a technical point that you can skip over with clever drafting, really. It's a deeply political, important point that's going to need discussing at some point.
Some are and some are not, I think would be the point. Yeah, okay. And then I think there's here... Have you already spoken? Yeah, sorry, let's go to the person at the back then. Just give everybody a chance if we can.
Yeah, I just want to echo Andrew Burrow's question and point about the mood music between the political and the technical. And it strikes me, I'm just coming back this morning, there were some Brexit ministers present in another part of this university. And indeed, their mood music is exactly what you just said. It's going to be easy. Their favorite paradigm is Indian independence, where India, put on its book all British laws before, and then says, as we become more and more independent, we'll reinvent them as we go along. And it strikes me that when they say this, they always speak about tariffs. That's basically their major example. And it's not just for public consumption. They really tend to believe that there's this very simple thing to distinguish between being in the single market and access to the single market. And so, to the extent that they will take Andrew Burr's point that, well, sometimes we will like an EU law and we'll just keep it on the books, they never consider or internalize the complex technical questions which have to do with mutual confidence in the enforcement of the law, in the enforcement of certification, in the enforcement of recognition of the quality of what we recognize in each other's laws, and all of the things you've all been talking about. That seems to escape them. Now, we could say, well, in these super ministries with hundreds of super bright civil servants and advised by lawyers, it will come. But how do you bridge that gap, that lack of understanding, that being part of a single market is not just the laws on the books, as India did when it gained its independence?
Yeah. I think I'm looking at it actually through a contract, commercial, consumer angle, and I would say that the majority of what we've got can just be reenacted. I agree entirely that there are some provisions that cannot, but an awful lot can. Clearly, one has to isolate which are the ones that really don't make any sense, as the sort of examples Rob's given. But the idea that none of this can be simply reenacted is, I think, incorrect. I'm sorry, I don't follow the Indian Contract Act or the Indian Act analogy. And maybe you're saying when India came out, independence of India.
This is not me. This is the, David Davis or Redwood, etc.
Okay. Well, thanks for the point. Maybe we'd have to think about whether it's quite like becoming independent from government by the UK if you come out of the EU. I sort of begin to see what you're saying. Yeah, okay, yeah.
I have sort of a question about the Article 50 process and maybe an observation on citizenship and immigration, as it wasn't mentioned. I mean, on Article 50, obviously it's a qualified majority vote in the Council and the European Parliament. And then obviously a new arrangement would be subject to different rules. So the division of labour between the two processes is going to be quite important. I don't think anybody on the UK side seems to have thought that through, but I'm curious if people have a view on that. And relatedly, given that it's a QMV in the leaving process, I mean, and this is to speculate a little bit about the political dynamics, but I guess one of my many nightmare scenarios involves, a UK government that wakes up and starts to think a bit strategically, but that involves making a lot of alliances with Central and Eastern European countries that are themselves lurching to the right, where you have a very strong Eurosceptic move, and sort of, creating a form of non-membership which is extremely divisive for the whole European project. And then we're just looking at blocking minorities and trying to rely on the European Parliament then to sort of be an active... so I mean, I'm just asking you to speculate a little bit about the more wider divisive impact across the EU, not just to think about it solely in the UK context.
Okay, thank you very much. Anybody else want to ask anything at this point? Okay. Could I then ask any of the panellists who wants to respond to that comment or... Yeah, a couple of things about that.
The way I look at it is that the Article 50 provides for the withdrawal agreement, which is about the details of separation, and that is qualified majority voting. But that doesn't provide for the new trade agreement and other agreements about all these other issues that need to be negotiated with the EU and the UK as a third country. In fact, some people, EU specialists, say that the negotiations for the separate long-term agreement will only begin after Britain leaves the EU. That seems to me entirely absurd. And now the situation then seems like there's going to be something like Article 50 process of withdrawal, then a sudden interregnum where the relations between the UK and the EU will be only by means of the WTO sort of rules or any other default rules. And then after the negotiations are concluded in 5 or 10 years, a new trade arrangement, either by way of Swiss agreement or Norway or whatever. Now, this seems to me completely crazy. I mean, I have 3 different legal regimes within 10 years. So I think what's going to happen is that Article 50 will be prolonged by unanimity, so that the negotiation will have to begin. But then that's where Britain will have to give in so much way of negotiation to those parties that you just mentioned to get their agreement. So triggering Article 50 has lots and lots of economic risks. And I don't think people have thought it through. People believe that Article 50 will signal the negotiation of everything. That's not clear at all. It'll be about the pensions of the officials and about the budget and about the funding arrangements for research, but not about the trade deals. That's a real political risk at the moment. It's not being properly debated, I think.
Just very quickly, and Calypso's comment. Oh, sorry, Calypso's comment up the back. I mean, I think the problem that we have is that, and this was a session we had in the environmental law section this morning on interdisciplinarity, other disciplines tend to see law as just technical. And that, I think, is the great risk in the Brexit debate, that the legal questions are just seen as we can fix this very quickly, rather than recognising that, law is a thick cultural phenomena, and what, has just happened, whatever has happened, is really a serious change to the legal order and the way we imagine and think about law. So, I mean, in a sense, your story scares me, because it is, going to Catherine, that is the nightmare, that law is not taken seriously.
Well, we may have different views about that. Does anybody have any further burning questions? I'm sorry I cut you off, so if you'd like to ask your question now, this may have to be the last, unless there is one more. Okay.
I'm just concerned about the whole transitional issues. Politicians are talking about the state of where we are at the moment and then being out of the EU, but of course everything has massive transitional complications. What happens with the dispute, if we withdraw on the 1st of Jan 2019, what happens about all the things that are in progress but not resolved at that date? That, in a sense, could be answered separately by every area on the panel, but I don't know whether you would like to comment on that, because it seems to me that the transitional issues might be an order of magnitude more complicated than the withdrawal issues.
Okay, thank you. And then Timothy?
I just wondered if any of the people in the second half of the programme think that the problems they talked about are of great concern in Brussels. The people who will be negotiating with Britain on behalf of the European Union, what will they really be concerned about? If I were there, I would want to have a fisheries deal. And I wonder what else that is really important from the European point of view in what you've been talking about.
Anybody want to tackle that?
I'm afraid what they want to do, will give a lesson to the UK because they dare to trigger Article 50 and make an example of something that you don't want to do. That's the most obvious thing you can think about what their priorities will be. Second, in many areas there will be the temptation to make the life of the UK harder when it's very competitive, so financial services equivalence will be a vision out there, a mirage. You won't easily get it because it's the occasion to gain some economic strength, the damage of the UK.
Thank you. I'm going to give the last word actually to Steve Weatherall, who, after all, is the Professor of European Law in Oxford.
Oh, the last of a dying breed, you might think. Look, what I think this second session has explained to us very clearly is that we've all got a stake in this. We're all engaged in the process of the Brexit. It's been very clear from the interesting presentations we've had is that there's an enormous sectoral variation in the entanglement of particular areas with European Union law. Glenn has talked about tax as being relatively unaffected by European Union law. That's mainly because tax is subject to European Union law, mainly in the fields of free movement and competition law, rules that stop states doing things. There's relatively little secondary legislation putting in place common standards for tax. Competition law is another story again, where the UK has freely adopted the EU model of competition law, mainly to reduce costs for businesses that are subject to those regimes. For environmental law, for labour law, for IP, for company, there's a relatively dense set of EU rules established mainly through directives, some regulations, which put in place common standards for the whole of the 28 member states. So the entanglement of the UK with the EU acquis is deep. That means, too, that there is an enormous sectoral variation in the possibilities for disentanglement of UK law from the EU. In part, that will be determined by the willingness of the UK to submit to the rules of the EU internal market in order to retain market access there too. The more that the UK agrees to accept those rules, the less the disentanglement that will be undergone in the particular sector in question. And then, as Louise has pointed out, it's not just about EU standards, it's about global standards as well, which in many cases are standards which have been promoted by the EU itself to maximise its global reach. There's very little escaping the European Union. So there's enormous sectoral variation in entanglement and in disentanglement from the EU. Can this be a creative process? Look, the EU is far from flawless. One of the great weaknesses of the EU is that it's slow to change. You can only change primary law, the treaty, by unanimous action of all the member states through the procedures foreseen for treaty revision by the treaty. They are cumbersome in the extreme. But secondary legislation's pretty hard to change as well. Assembling a qualified majority vote on a Commission proposal with parliamentary support is needed in most areas to change EU secondary law. That's not easy to achieve. The EU is pretty slow to change. That's a weakness. If the UK does remove itself from the European Union, which is my no means certain, we'll at least be in a position where it will no longer be possible for scholars to say this is the law in the UK because the EU says it is the law. We'll have to become more active as scholars in promoting our particular preference, our particular regulatory vision. Liz has already emphasised the role of scholars in this process. She's right. We'll need to talk much more clearly about the function of labour law, of environmental law, of consumer law in challenging market imperfections and market inequities. So there might be a possibility for an energetic, creative process of scholarship insofar as the UK removes itself from the influence of the EU, and therefore we have to have these sorts of debates within the UK rather than simply through Brussels. So I try to end on a positive note, Andy.
I'm sure you wish to join me in thanking our panel members. We've tried to give a snapshot of the many and complex and varied issues that this debate has engendered, and no doubt it will continue for a considerable period of time, one suspects. But thank you very much for coming. But thank you, panellists, and I hope we, in the normal way, show our appreciation for